Are you charged with an assault and battery here in Virginia, and you want to know how Virginia defines assault and battery? Watch this video and we'll tell you what we think. Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, let's talk about Virginia assault and battery charges. If you're facing a charge, or if you have a friend or a family member that's facing a charge, maybe you've sworn out a warrant for assault and battery. This video is going to help explain how Virginia defines assault and battery, because surprisingly, it's not as simple as one would think. So if you actually look at the Virginia Code, assault and battery is noted at Virginia Code 18.2-57. And in that statute, if you'll look, it actually simply defines what an assault and battery is punishable by. And under Virginia law, that's a class 1 misdemeanor. I think the code section for that is 18.2-11. And under a class 1 misdemeanor, you can get up to a year in jail and up to a $2,500 fine, or both, in addition to other types of punishments. But those are really the main ones. But that just gives you the definition of it. How do you actually define assault and battery? Well, surprisingly, the code doesn't actually lay it out. It doesn't say assault and battery is X, Y, and Z and lay out the elements. Virginia has essentially developed the definition of assault and battery over what we call common law. And common law is really, over the years and centuries, cases have come down to define what a criminal offense is. And this is one of these instances. So it's kind of surprising when people learn that assault and battery is not actually in our code, but under common law. And so the easiest way that I tell people to determine how to understand the definition of assault and battery is looking at what we call our Virginia model jury instructions. So what is a model jury instruction? Whenever I, as an attorney, am getting ready to do a jury trial and I'm representing a client, the Virginia model jury instructions were essentially a very uniform set of ways, essentially rules, the laws themselves that have been created throughout the years to define crimes. And so they also define a lot of other things, but you can actually get a book. It's called the Virginia Model Jury Instructions. I think the current version is done by LexisNexis, but you can look at that. And if you look at Virginia Model Jury Instructions, there's a specific definition for what an assault is and for what a battery is. So let's talk about what an assault is, and we're going to look at Virginia Model Jury Instructions 37.350. And that says an assault is an overt act intended to do bodily harm to another, together with the present ability to cause such harm, or an overt act intended to place a person in fear or apprehension of bodily harm that creates him or her a reasonable fear or apprehension. So that's the definition of assault. Now, Virginia Model Jury Instruction 37.300 defines a battery, and that says that a battery is a willful touching of another without legal excuse or justification, done in an angry, rude, insulting, or vengeful manner. So that's how our model jury instructions define an assault and battery. And I'm going to go a little bit further, and I'm going to give you a case that I think it does a very good job about kind of summarizing the assault and battery. And the reason I know it well is because I actually, along with a co-counsel, ended up trying this case to a jury. We lost, unfortunately, and then the case was appealed. So the Court of Appeals brought up the case, and this really dealt with what an assault and battery was. And the case site is Parish versus Commonwealth, Virginia VA App 324, and this is a year 2010. And in it, the court provides, and I'm going to summarize here, but I'm going to read it, essentially a summary of what their quote is. So it says, Code Section 18.2-57 provides that, quote, any person who commits a simple assault or assault and battery shall be guilty of a class 1 misdemeanor, end quote. It goes on, because Code 18.2-57 does not define assault or battery, we must look to the common law definition of the term. So again, common law. The crime of assault and the crime of battery are independent criminal acts, although they are linked in Code Section 18.2-57. So yes, as we talked about in the model jury instructions, there's definitions for both. So the court goes on to say, to sustain a conviction for an assault, the Commonwealth must prove, quote, an attempt or offer with force and violence to do some bodily injury of another, end quote. The attempt or offer to do bodily harm occurs when an assailant engages in overt act intended to inflict bodily harm while he or she has the present ability to inflict such harm, or the assailant engaged in an overt act intended to place the victim in fear or apprehension of bodily harm and create such a reasonable fear or apprehension of the victim. And it goes on to say, because assault requires an overt act, words alone are never sufficient to constitute an assault. And lastly, it goes on to say, to sustain a conviction for battery, the Commonwealth must prove a willful or unlawful touching of another. It is not necessary that the touching result in injury to the victim's corporal person. It's sufficient it does injury to the victim's mind or feelings. So as you can see there, both the model jury instructions and Parish versus Commonwealth point out that assault and battery are actually two separate things. So you can be guilty of an assault, you can be guilty of a battery, and of course you can be guilty of an assault and battery. So that's something to be thinking about whenever you're charged with a crime, and how that plays out in litigation. It will depend on each case, but when I get to the end of this, I'm going to be recommending that you get an attorney for an assault and battery charge if you can afford one. If you can't, then ask for court-appointed counsel, because if you're charged with an assault and battery, it's a very serious charge and you need representation. These cases are ripe for litigation, particularly if you have certain defenses. So let's talk about a few things to consider when you're charged with assault and battery. Number one, no injury was required. The complaining witness doesn't have to say they were injured. They don't have to show pictures of bruising. A push, a shove is enough for a battery. Heck, for an assault, no touching at all is required. So let's say you're alleged to have thrown a beer bottle at somebody and they got scared and had to duck. That's arguably an assault under Virginia law. You need to be very aware of that. Now, again, words alone can never amount to an assault of any kind. So simply saying something to somebody is not an assault. So those are a couple things. And the point here, though, is to consider that an assault and battery in Virginia, there's a relatively low threshold. Someone alleges that you pushed them. Somebody alleges that you punched them. Somebody alleges that you threw something at them. Somebody alleges that you bucked up at them and making them think you're going to hit them and you intended to do that. That can be assault. That can be a battery, or it can be assault and battery, depending on how it's charged. So unfortunately, I see this a lot. A lot of cases I get end up being assaults, battery charges, or domestic assaults, because of the assault and battery definition applies not just in a simple assault, but there's domestic assault, simple assault. There is assault on law enforcement. There's other types of assaults within the Virginia Code that encapsulates this behavior that are punished differently and have different criminal codes. But just be aware what we're talking about here is the overall definition of assault and battery. So let's talk about a couple things. What if you're innocent? What if you say, James, I didn't commit this crime. I don't know what they're talking about. They're lying, or that didn't really happen the way they said it happened. Actually know that it was their fault, that kind of thing. First of all, if you're innocent of a crime of assault and battery, again, I can't emphasize this enough. Get an attorney, because you got to be in a position where you can actually litigate the case. You don't want to be in a position where you're forced to take a plea or deferred finding or whatever may be offered, and you haven't done your due diligence. You're scared, so you just take whatever comes down the pike because it sounds better than potentially going to jail for a year. In fact, for a nominal assault, meaning no claim of injury, somebody pushed me or punched me or threw something at me and there's no injury. In my experience, jail time isn't really the main concern. In fact, it's rare that I'll see jail time for a simple assault, alleged no injuries and all that. Of course, that caveat that every jurisdiction is different, every judge is different. But typically speaking, for a first-time simple assault case, we're not looking at jail time as the main concern. It's the conviction itself, which can have serious impacts on security clearances, licenses, immigration, perhaps, those kinds of things, which are outside the scope of this video. But my point being that you need to be aware that there are going to be consequences of having a Class 1 misdemeanor, arguably violent conviction on your record, and you should do your due diligence, talk to an attorney. I would recommend hiring an attorney or getting one court appointed. When it comes to evidence, let's say you say, well, I've got video of the incident, or I've got this person texting me, threatening me or I've got a witness that can say that didn't happen. Do yourself a favor and preserve that evidence even before you talk to an attorney. You don't have to have an attorney to preserve evidence for a case. In fact, if you can hand that evidence to your attorney on a silver platter, that makes that attorney's job much easier. And you may think, well, I'm taking away the attorney's work. The easier you can make their life, the better, because that increases your chances of being acquitted of the charge or some other resolution of the charge. It maximizes the chance of getting a good outcome or mitigating the damages of a bad outcome. So that's what I'll say on that. Now, there are certain other instances that I see often. One is, hey, I was defending myself. Under Virginia law, you can absolutely use self-defense as a defense here. And so I'm looking at Foster versus Commonwealth. This is a court case at the Court of Appeals. Foster versus Commonwealth. This is 13 Virginia App 380 at 1991. So if you Google that, you should be able to find that case. But it essentially says a person who reasonably apprehends bodily harm by another is privileged to exercise a reasonable force to repel the assault. However, the amount of force used to defend oneself must not be excessive. It must be reasonable in relation to the perceived threat. So what that essentially says is look, you are able to use self-defense reasonably. So if somebody's trying to punch you, you can avoid them and then punch them back if you're going to be repelling that assault because you're worried they're coming after you. And again, this is just anecdotes. Don't take this as legal advice. Don't do these things. But I'm just talking about how the law is written. If somebody tries to use greater force, then you're able to use proportional force relative to repel the assault. You can't go beat them up because they tried to start a fight with you, and then once they're on the ground, keep pounding them in the sand. You can't do that. You've got to use proportional response. The other thing is you cannot use self-defense if you were the aggressor. So this is Sims versus Commonwealth 143, Virginia 736, 1922. That essentially says if you started a fight and that person responds, you can't then say, oh, I was defending myself because I punched him, he punched me back, and then I was just punching him to defend myself. It doesn't work like that. You've essentially got to retreat to the furthest, at least under the law, you have to retreat to the furthest available possibility. And then despite retreating, the other person's still the aggressor, but you don't want to be in that situation. So don't start fights or you're looking to get yourself in trouble. Now, there is another concept that's called a mutual combat. So in plain terms, two people want to fight each other. Now, I want to be clear, under Virginia law, this has not technically been recognized as a defense. There's been cases that have referenced it. For instance, there's a case, Bilal versus Commonwealth. This is out of the Court of Appeals in 2002. It's on Washington or Westlaw site 31817987. Now it talks about mutual combat, and it cited a case, Harper versus Commonwealth. That's 165 Virginia 816-1936, where mutual combat was used to reduce a manslaughter charge from a murder charge. So essentially use the culpability brought down. But just to be clear, it's not necessarily defense. There's an argument for it to be defense. But the reality is, in today's society, as we're sitting here in 2022, if somebody wants to fight you, don't fight them. Okay. It's not worth it. You don't need to stand up and prove how strong you are. If the person wants to go do a regulated boxing match, fine. But in our world, move on. You've got better, more important things to do. The last thing you want to do is find yourself charged with a crime because you want to fight that the other person arguably want to be involved in. I also do personal injury here. The last thing you want to do is get civilly sued because you've hurt somebody in a fight and you didn't intend to. But now the question is whether or not they contributed to the injuries and all that. You don't want to get involved in that litigation. So don't get in mutual combats. It's not worth it. Okay. So hopefully this video was enlightening. It gave you some reference points to think about your criminal charge if you're charged with assault and battery, or if you're just trying to learn about what assault and battery is. The long and short of it is it's more complicated than you would think. It's probably more complicated than it should be, but that's life. And Virginia law can sometimes be confusing, but at least I've given you some frameworks to think about it. Hopefully this is useful information. And again, I recommend you get an attorney if you're charged with assault and battery. You can feel free to give us a call. Phone number is 703-570-4180. check us out, www.abreniolaw.com. We'd love to help you. But if it's not me, make sure it's somebody else, because the last thing you want to do is have to call me on an appeal and say, look, I should have listened to you. I got convicted, and now if you were in general district court, you wasted that opportunity there. And if you've been convicted in circuit court and you've got appealed up to the Court of Appeals, that's going to be a hard-fought battle. So wish you the best. Until I hear from you, take care. If you're watching this on YouTube, make sure to subscribe to Abrenio Law's YouTube channel. We're constantly putting videos, writing articles out, and hopefully it's useful to anybody that's watching. So we wish you the best. Take care. Bye.